Yeah, let's talk a little bit more. We talked a little bit about this already. Let's talk about the F&E tax a little bit more in context that are going to be applicable, I think, to this group. So I think that there would be two exemptions from the Tennessee F&E tax that you want to keep in mind. The first, I think, is going to come into play a lot of times here. It is the family-owned non-corporate entity exemption, or the acronym is the FONTS exemption. So if you got an LLC, so let me step back a little bit. The franchise and excise tax applies to LLCs, it applies to limited partnerships, it also applies to corporations and S corporations, but we're not going to talk about those because we're not going to use them, right? So really, we're talking about LLCs and limited partnerships. It does not apply to general partnerships, okay? And so here's sort of the rationale behind that. What the state says is, look, if you want the benefit of a state law limited liability shield in terms of personal liability protection from creditors, if you want the state to give you that liability shield in the form of the state law protection you get with an LLC or limited partnership, that's great, but you got to pay the man. All right, you got to pay the state of Tennessee for that extra insurance that you're getting. And the cost of that extra insurance are your sort of annual administrative costs you got to pay the state of Tennessee and the F&E taxes, okay? And so, but the state then says, okay, but we're going to provide for some exemptions from the F&E taxes. And one of the exemptions is this FONTS exemption. So if you got an LLC that is 95% or more owned by members of the same family, and there's a complicated lawyer definition of who's members of the same family, but you can generally use a common sense approach. You know, if it's wife and husband and children, or mama and children, or, you know, first cousins. I mean, it's you know, you're probably not going to have big problems on that as long as everyone is sitting around the table actually looks like your family. And so here's the key. Substantially all of the income of the LLC has got to be passive. And what the Tennessee Department of Revenue says is that substantially all means at least 2/3. All right? And so let me tell you what's passive and what's not passive. Interest, dividends, royalties, that's passive. Okay? Real estate rent is not passive unless it is real estate rent from 1 to 4 unit residential property. All right? So if you got a single family home, duplex, triplex, or fourplex, the rent from those is passive. And you can own 100 of those and qualify, as long as you meet the 95% family ownership thing, you can qualify for the FONTS exemption. But if you throw in there 2 15-unit apartment buildings, all right, the rental income from those 2 15-unit apartment buildings are not going to be passive income, okay? And so if the income from your more than 4-unit residential is more than 1/3 of the LLC's total income, you just blown your exemption, okay? And you got to pay F&E tax on the whole kit and caboodle, all right? All right. The other exemption that we use, and I'm not going to spend a lot of time on it in here, but we use it fairly frequently in the commercial context, is the obligated member entity exemption, all right? Which means you can go out and set up an LLC or limited partnership, and if all the owners agree in writing in the organizational documents to be fully liable for everything, just as if they were general partners. In other words, if they waive the benefit of the state law liability protection, the state says you're exempt. If you don't get the benefit of limited liability protection, we're not going to make you pay the man. All right? Yes, sir?
Can those members be foreign entities like out-of-state limited liability companies?
Well, so I'm going to answer the question this way, and you're just going to have to sort of take a cleansing breath on this as I sort of work through the answer to this question. On these exemptions, let's say that I've got an obligated member in it. Let's say I've got an LLC that has 2 members, okay? And the 2 members of that LLC, one is a human being and one is another LLC, okay? And those 2 members agree to this obligated member entity exemption. So the human and the other LLC both agree to be fully liable for the debts of that LLC. At that level, they'll have the exemption, okay? But then the state's going to look beyond that, and they're going to look upstream to that other LLC owner, right? And they're going to see, okay, there's another limited liability entity in the upstream ownership, and that entity is going to have to pay the tax unless it has its own separate exemption. You see what I'm saying? So ultimately with this exemption, to really fully get the exemption, you've got to trace the liability all the way up to human beings. Okay? I mean, that's a little bit of an oversimplification, but not too much, because if you start trying to get fancy and interpose other liability entities, limited liability entities upstream, you're going to end up having to pay the tax up there.
So I guess the same would apply if you got a general partnership in Tennessee, and the members, and the partners were foreign LLCs, it would still.
Or yes, or two Tennessee LLCs. If you had a general partnership composed of two LLCs, which you could certainly have, the general partnership itself is going to be exempt. Okay. However, each of those LLCs is going, to the extent that they are qualified to do business in Tennessee, are going to have to pay Tennessee F&E tax on their respective shares of the general partnership's income and assets.
Even if they are out of state, will be the same.
So, the answer to your question is, if those out-of-state LLCs have to qualify to do business in Tennessee, as part of the process of qualifying to do business, they're going to subject themselves to Tennessee F&E tax. Okay? So that's really the answer to the question. And I will say this, in most cases, a general partner of a partnership probably would have to, technically should qualify to do business in the state of Tennessee.
Even if they're just holding the property.
We got two lawyers talking here, so I don't want to take too deep a dive on this. But
Let's hold on.
okay, all right, sorry, all right, good. Okay, sorry, all right. Yeah, so, but I will piggyback on that, on this one thing. So let's say, for example, let's say that you had a deal, let's say you had an apartment deal, okay, and it had more than 4 units. So you know that you can't qualify for the funds exemption, but you don't want to pay the tax. And let's say you're in it with 3 other people. And let's say that the 3 people, let's say you've got one of the persons is a young, up-and-coming 28-year-old investor who's aggressive and doesn't want to pay the tax and doesn't have any assets. And one of the other owners is that person's father, who is a radiologist, who's got a lot of assets, who's bankrolling this thing. And another person is just another real estate investor, who also, who's putting a little money in. So with a situation like that, the young Turk who doesn't have that much assets, he may say, wow, Red I want to pay $2,500 for $1 million worth of asset value and 6% of net operating income every year to the state of Tennessee. I don't want to do that. That's crazy. We're not, we're going to do this obligated member entity exemption. And his father, the radiologist, is going to say, look, I'm just doing this to pacify your mother anyway. And so, there's no way in the world I'm subjecting everything I work for to this harebrained idea of yours. Okay? And so he doesn't want to be liable. And, maybe the other real estate investor is kind of somewhere in between. What you could do there is you could set the thing up as a general partnership. You could have the risk-preferring son participate himself as a general partner. You could have the risk-averse father hold his interest through a single-member LLC, right? And then the other real estate investor can do what he wants to do. The net effect of which is the dad who holds his general partnership interest through an LLC is going to have to pay his share of the F&E taxes. It's going to get specially allocated to him, and he'll have to pay it. He'll have to pay his share of the tax. But the son says, I'm willing to go naked, I'm not paying the tax, and so everyone sort of gets to have their cake and eat it too under that approach.
Richard, one quick question on that scenario. Could you fractionalize that apartment building? Let's say it's 16 units, break it down into 4 separate.
Hold on a second, Kevin. Let's get a microphone.